Afternoon, right?
I know.
All right, everybody, let's get started. We have a pretty tight schedule to get us through to the end of the day and to happy hour and hors d'oeuvres. So thanks to all of you that are here for this panel, Water Wars Between States, Do Interstate Compacts Help or Hurt? A case study of Tarrant versus Herrmann. My name is Tom Romero. I'm a faculty member here at the Sturm College of Law. I teach our introductory water law course. I also serve as faculty advisor for the Water Law Review. And I want to thank all of you today for supporting the students of the Water Law Review who have put this together. You've probably heard, and we've sort of seen in different venues, all the ways from the work that the students have done to make this a compelling conversation, to make you all feel comfortable and at home. And this is all done from our students. And I just can't say enough about them and their professionalism and their enthusiasm for growing this journal. As some of you may have heard last night, we'll be entering the 20-year anniversary of the journal next year, 10-year anniversary of the symposium next year. So if we could all give a quick hand to the students in here, I'd really appreciate it. In putting this panel together, Blaine and I were sort of talking about the importance and how critical it was to start talking about other compacts that exist outside of Colorado. And it was really important to think about how these compacts might differ and in both scope and form. And this 2013 Supreme Court case of Tarrant Regional Water District versus Herrmann and the compact between Oklahoma, Texas, Louisiana, and Arkansas over the Red River provided the perfect vehicle to not only explore how other states have used compacts to resolve their water disputes, but to do so in context of the Dormant Commerce Clause, something I know we all get excited about, and water marketing issues that hadn't been evaluated by the Supreme Court since a case involving Nebraska and Colorado over 30 years ago. Now, to dig into the details of this case and have somewhat of a point-counterpoint, we have Kevin Patrick and Star Waring. You can read their impressive bios in the program, but I did want to say a few things about each of them. Kevin Patrick, as you will notice in his bio, writes novels. And his first novel, Threatened Waters, obviously sort of his novels build upon his expertise and his thinking about water law and water disputes in probably sort of in a very interesting sort of narrative context. I just wanted to bring this quote that one of the reviews on Amazon had about his first book. I am also wondering what it is about lawyers that can churn out books that have a surprising tension and depth in an age of shallow, short, and predictable. So if there's something about the lawyers, all of you future lawyers in here, you can start thinking about your future writing careers. Kevin's sort of a good model for that. And then we have Star Waring, who most recently is our practitioner in residence for our Natural Resources and Environmental Law program here. And I've known Star since I came to the University of Denver Sturm College of Law in 2010. And what I've learned right off the bat is she's incredibly giving of her time, she's incredibly giving of her expertise, and she's incredibly knowledgeable, and she gives that not only to faculty like myself and newbies like myself to the University of Denver, but in particular to our students. She's been a professor in our water law course. She's guest lectured. She's been a mentor, and I can't thank her enough for the tremendous service that she does and that she models for many in the water law bar here in Colorado and in other states of this important work and for our future lawyers. All right, so very quickly in terms of our time, we have a format here in which Kevin and Star are going to they have this PowerPoint presentation. They're going to give us some background and context of this case, and they're going to try to present as faithfully and objectively, maybe not objectively as possible, the multiple issues in this case. We're going to end up here with a set of questions that we've developed that this case raises. And if we have time, we then hope to solicit questions from the audience. So without further ado.
Great. Well, I'll jump in first. I'm very pleased to be here today. I enjoy teaching at DU and meeting all of you. I'm actually filling in for Susan Ryan, who's on maternity leave, somewhat unexpectedly in her case. Her baby came much earlier than she thought. And so she asked me to fill in. But Susan and her law partner, Brian Nazarenas, who are Denver lawyers at Riley, Carlock, and Applewhite, represented two of the amicus parties in the case. So she's uber familiar with the Oklahoma side of the arguments. Her two clients, Oklahoma City and the Oklahoma City Water Utilities Trust, supported Oklahoma City, the Oklahoma Water Resources Board, who was essentially the defendant in the case. So my goal here today is to kind of channel Susan. She helped put together the PowerPoint presentation, so I'm going to deliver her thoughts and be more supportive of the Oklahoma side of the argument. We are going to try to do somewhat of a point-counterpoint, but we'll try not to let the format mirror some of the recent political debates amongst the candidates, so we'll be civil. Anyway, we'll walk through the compact itself and get into a little bit of the background for it, and then the procedural posture of this case, which has worked its way up to the Supreme Court. I was curious to know how many of you have actually read the opinion. A few, so we'll try to fill you in with as much background as we can, and I'll turn it over to Kevin.
Thank you. I had the good fortune of representing Tarrant Regional Water District, which was the lead agency among four agencies. It was Dallas Water Utilities, North Texas Municipal Water District, Trinity Regional Water District, and of course Tarrant Regional. And they supply in total about 4 million people. Tarrant Regional supplied about 2 to 2.5 million people. And it's always interesting to me when you go to these conferences and you hear these discussions about compacts, and they're talked about in a vacuum. And these cases are talked about in a vacuum. So it's always helpful to look at how they came up, how they started. And so I want to give you a little background of before the litigation started. So in the beginning, it was 1819. In 1819, the U.S. signed a treaty with Mexico, the Treaty of Amity, Settlement. Okay, Amity, Settlement, and Limits between the United States of America and His Catholic Majesty on behalf of the Republic of Mexico. Signed and negotiated by John Quincy Adams. And one of the things that he wanted so desperately to do is to give no access to Mexico to the Red River. Mexico would not touch the Red River, would have no navigation of the Red River, have no access and use of the Red River or the waters in it. So I don't know if you know the history of Texas, Texas was its own country, because by winning its independence from Mexico, it succeeded to whatever Mexico had. So Mexico came into the United States not having any access to the Red River. And that was perpetuated in the Red River Boundary Compact with a couple of incredibly minor exceptions. And so here we are, fast forwarding 1980. There's been many conflicts, mostly about oil and gas operations at the border. But in 1980, the Red River Boundary Compact came into existence and the Compact came into existence. They were both passed in the same year. During the 20 years it took to negotiate the Compact, there were federal reservoirs seeking authorization to be built. So you have to understand that in Oklahoma, which is water prolific, 60 inches of rainfall just on the north side of the Red River. In contrast, 10 miles to the south, you've got 18 to 20 inches of rainfall in Texas. So there's just an anomaly of nature that causes southeastern Oklahoma to be water abundant, whereas Texas is water short. So here you had a bunch of federal reservoirs seeking authorization from Congress. And they were known as the last major dam sites. And that's important because that's how the Subbasin 5 which is the sub-basin within the Red River Compact that was the subject of the litigation. How that was described within the compact was not state line, not state. It was defined by a perimeter of these last major dam sites. And we'll get a little bit further into that. We'll talk a little bit about how Oklahoma came and sought Texas's help in obtaining authorization from those reservoirs. One last thing is, just so you get a feel, you talked about the Colorado River probably ad nauseum today. And the Colorado River flows, what, 13.2, 13.8 on a good year, more, million acre feet. After all uses in Oklahoma, which are about 1.5 million acre feet, after all uses, 32.5 to 34 million acre feet flows out of Oklahoma to the Red River. So it's huge, the volume of water that's coming out of Oklahoma.
So I would just jump in here and add that I don't really agree with Kevin's characterization of water use and water demand in Oklahoma. You know, the southeastern part of Oklahoma is, you know, very abundant, relatively speaking. It's wet. It's up to 60 inches of precipitation. But when you look at the western side of Oklahoma, it's very dry. And that's where its major metropolitan area is located, the city of Oklahoma City. There's probably not much more than 20 inches of precipitation on average, which is similar or comparable to the Dallas-Fort Worth area that the Tarrant district served. So Oklahoma City had actually put in some reservoirs in the southeastern part of the state to provide water for Oklahoma City. And Oklahoma City's growing. It's certainly not a huge metropolitan area compared to the Dallas-Fort Worth area, but there is an increasing water demand, and Oklahoma felt that it needed these water resources and wasn't willing to give them up to the state of Texas. So that's part of the backdrop.
And I'll do a counterpoint there. just let you know that 34 million acre feet of water, Oklahoma City had applied for 80,000 acre feet. And and we'd applied for 310,000 acre feet. So there was still 34 million acre feet just going out of state.
Point noted. So I guess let's...
Well, maybe the first thing to do is let's talk about Reach 2 Subbasin 5.
Okay. Did you?
And I'll give you the map here. In blue is the subbasin that was litigated. As you can see, the Red River itself was divided into reaches and subbasins within those reaches. Everything above the last major dam sites was allocated for the exclusive use of the particular state in which it's located. Whereas the blue area was, as you can see, below these last major dam sites, which are these green circles. And the two black circles are where Tarrant sought to take water, about 10 miles from the border with no water users below. So it was a geographically defined basin, no mention of state lines. And this geographically defined basin was, according to the legislative history, defined as excess water. Water after all uses had been used within the two states, right before it entered the Red River. The reason why no one takes water out of the Red River main stem is it's naturally polluted by chlorides. And there's, it was stipulated between all parties that it was so contaminated that it was not acceptable for any beneficial use.
So this, and I think we'll look at that provision next, the provision of the contract, of the compact that was in dispute here. But it provides specifically, it includes the main stem of the Red River, which is located in 3 of the 4 states that are involved in this compact. The compact signatories are Texas, Oklahoma, Louisiana, and Arkansas. And obviously the motivation was to make sure that the downstream states were getting sufficient water from the Red River. So that's...
Yeah. One of the things is that the way this is drafted, anytime there's 3,000 acre feet, 3,000 cubic feet per second at a particular point, then all 4 states have an equal right to take up to 25% of the river and of the flow within that subbasin. That occurs 96% of the time. The next section down says what happens if you don't have that amount of flow, which happens 4% of the time. And then when there's low flows, when you begin to have severe administration on the river, then that has happened never, and it is estimated to occur 0.02% of the time. So this provision governs 96% of the time there's excess water.
Oh, I should add too, on this provision that's at issue, section 5.05, parentheses B1, that was the most contentious and difficult part of the compact to negotiate. It took them a long time to come up with a scheme to deal with the water allocation in that reach, so, or in that subsection of the river.
You want to go through the overview?
Yeah, but before I do that, I want to mention too that, we have this provision, but there are a number of provisions in the compact that we'll talk about later that strongly favor or demonstrated that each state was to have authority to administer water within its state boundaries. And the Supreme Court later focused on that part of the discussion. A lot of the provisions were intended to give each state free and unrestricted use of the water within its boundaries. So Texas wanted to come in and take water within the boundaries of the state of Oklahoma, and that's really the bottom line and what the issues were in the case.
Yeah, Oklahoma, let me back up. Oklahoma had adopted a moratorium against any out-of-state water use. And they had adopted a panoply of laws which discriminated against anyone taking water across state lines. Mm-hmm. Bear in mind, we have the Altus versus Carr case in which Oklahoma is taking water and takes water to this day from Texas. But Oklahoma switched and started taking, the legislators started taking very aggressive steps, and that was primarily in response to an effort by Oklahoma to sell water to Texas. In the 1990s up through 2002, Oklahoma sought to sell water to Texas, recognizing the abundance in this basin and above this basin. So they actually put out an RFP seeking buyers for Oklahoma water. And they sought specifically Texas. Several entities came in, one of which was a group that was composed of Tarrant, Dallas Utilities, and one other party, not the original 4 that were in this case. But that was a turnkey operation where Oklahoma said, we are going to handle permitting, we're going to handle condemnation, we're going to build the pipeline, we're going to finance it. And we're going to then lease you the water from our compact share out of Reach 1, not Reach 2, above this basin. And we will pipe it all the way to the Metroplex. In return, you will pay whatever you make your RFP. You'll give us an offer. So Tarrant, Dallas Utilities, and North Texas did, in fact, submit an RFP, did make an offer. Those proceeds would have been to a joint tribal compact, state tribal compact. So the tribes, Chickasaw and Choctaw, which are in this area of Oklahoma, would have gotten 50% of the money. Oklahoma would have gotten 50% of the money. The legislature blew that up after it was ready to be signed, ready to be inked. And it blew it up because they didn't, well, let me put it this way, this is my opinion, certainly not my clients, but there was a lot of tension with gambling in the tribes. They didn't want the tribes to participate that much in the revenue stream. And there was a lot of issues over tobacco sales and casinos in Oklahoma. So it fell apart not because of Texas, it fell apart because of internal strife within Oklahoma. But later on, the Supreme Court pointed to this prior course of conduct as grounds for their interpretation, which we'll get to.
That's right. That was a major factor, actually, in the court's decision, is why would Tarrant have, tried to buy water rights from the state of Oklahoma if, in fact, it had the right to come in and divert that water in Oklahoma from the Red River tributary, the Kiamichi.
Yeah, we obviously didn't do a good enough job of explaining that that was a different animal. It was Oklahoma's compact share. It was coming from Reach 1, not Reach 2. It was a turnkey operation financed by Oklahoma and delivered with no permitting and condemnation. So to us, it was a different deal.
Well, and one of the problems, or it's not necessarily a problem, but an issue is that this case was decided in the lower court on motions for summary judgment, so there was no trial. There was no record developed in the case. So perhaps some of these background facts could have been developed more fully if the case had actually gone to trial, but it did not.
Yeah, in fact, it was, Oklahoma filed a motion for, well, back up. Oklahoma filed a motion to dismiss for indispensable parties, abstention, and 11th Amendment immunity. It went to the 10th Circuit. Tarrant won that, and went back to the trial court. Then a second summary judgment motion was filed by Oklahoma as to the Commerce Clause claim. No summary judgment motion was filed on the preemption claim. And the court, sua sponte, without any discussion, ruled on the preemption claim in a two-sentence paragraph, stating that if that the compact itself says that no pre-existing law is to be considered overturned by the drafting of by the execution of the compact if it is consistent with the compact. And that somewhat is circular because it begs the question of whether or not the law was inconsistent with the compact under the preemption doctrine. But that's the setting, no factual determinations. There's a lot that went in the record, but essentially no trial and no discussion at all with the preemption claim, which was ultimately 99% of the Supreme Court's opinion.
Mm-hmm. So there was also this claim that these Oklahoma statutes, which my understanding is did not actually completely forbid the exportation of water, but they imposed more difficult burdens on out-of-state applicants. And apparently, Kevin and I were talking about this before during the break, that Tarrant's application is still pending. And who knows if and when it will be decided. But so it wasn't out and out, the application wasn't out and out dismissed, but it's a very difficult burden for an out-of-state applicant due to a variety of these statutes that the court called anti-export statutes, such as we've seen in other states. But anyway, one of the claims that Tarrant made was that the statutes violated the Dormant Commerce Clause. Does everybody know what that is? Yes, two people. It's a doctrine that courts have inferred from the Commerce Clause in the Constitution. So the Commerce Clause gives Congress the power to regulate commerce. And the flip side of that, which is implied, is that the states are then prohibited from passing legislation that improperly burdens or discriminates against interstate commerce. And that was the claim in this case, is that these Oklahoma statutes that made it more difficult for out-of-state applicants would violate this dormant commerce clause.
When it went up to the 10th Circuit, what was argued was essentially the Dormant Commerce Clause, because that was the basis of the court's opinion. And the Dormant Commerce Clause, you're right, it says basically you can't discriminate against interstate commerce unless Congress has given a clear statement. It's called the clear statement rule, that it entitles to discrimination. Congress says you may discriminate on a certain field or a certain manner. Historically, the clear statement rule, the Supreme Court has held that you may never look at legislative history, because if you have to look at legislative history, it wasn't clear within the statement made within the act. So by definition, you cannot cobble together interpretive comments, broad sections out of a statute and satisfy the clear statement rule. And that's one thing that the Tarrant case does. And if you look at how the authors are talking about the Tarrant case, they're viewing it as a relaxation of the clear statement rule, which we'll probably see in other types of commerce other than water. The second thing is when it went up to the 10th Circuit, the 10th Circuit basically ruled that there is a presumption against preemption. Now, that essentially says that when Congress passes a law, there's a presumption that it doesn't intend to preempt state law. So whenever you interpret a federal statute on a preemption claim, you have to take that into consideration. When it went up on the Supreme Court, of course, that presumption against preemption was thrown out because, as Dave Robbins said to the other question that he had, it's not really a federal law being jammed down a state's throat, which would give rise to the presumption against preemption. Instead, these states come together, so it has no application. States voluntarily give up a portion of their sovereignty when they sign compacts. So the presumption against preemption really has no place in this context. The 10th Circuit also found that these sections saying that a state was free to regulate within their boundaries, the 10th Circuit left off the second half of the clause, which says subject to the apportionments made within the compact. And so that was the focus primarily of the appeal before the 10th Circuit, is whether or not the Dormant Commerce Clause had been displaced by a clear statement rule.
You pretty much went through them.
Yes.
Okay. So, I guess, let me start that one.
Well, having lost at the 10th Circuit, we filed a petition for certiorari. And the court rarely, it happens more often in water cases, but the court rarely requests the opinion of the Solicitor General. And the Solicitor's Office was requested in our case to provide its opinions of whether or not the case should be accepted for cert and whether or not the United States agrees with one party or the other. That's called the CVSG. And the CVSG came out in favor of Tarrant, with the United States Solicitor stating that the Dormant Commerce Clause need not be addressed within the case. And second, that the plain reading of the compact, and it gives the better case to Tarrant, that the Subbasin 5 was defined by geographic boundaries without reference to state lines, and was a common pool from which all four states were to take their water. And the reasoning that the Solicitor General used in part was that the idea that each state could only use that portion of Subbasin 5 occurring within their state would have meant Louisiana didn't get anything, because Louisiana isn't even in Subbasin 5. No portion of Subbasin 5 exists within Louisiana. So that was essentially a good news for Tarrant, because usually when the Solicitor General gets on your side, you tend to get cert, number one, and number two, you stand a better chance of ultimately succeeding.
So the Supreme Court focused on some, in addition to Section 5.05, looked at some key provisions of the compact. And I alluded to these earlier, but Oklahoma had argued that the compact strongly supported the rights of individual states to administer water rights within their borders under their respective allocation systems. And there were a number of provisions of the compact, including the ones mentioned in this slide. Section 2.01, each signatory state may use the water allocated to it by the compact in any manner deemed beneficial by that state. That gives a broad latitude to the states. Similar language in Section 2.10. And then a number of others can be read very clearly as favoring each state having the authority to have free and unrestricted allocation rights over water within their borders. So those were favored by the court. There are a number of those, and they're cited in the slide. But there were others that might be interpreted otherwise.
Yeah, there were others interesting that the court really didn't address. Go back to my comments about these federal reservoirs, these last major dam sites, and go back to the 50s when this contract was being negotiated, 50s, 60s. And interestingly, Oklahoma sought reservoirs within their borders for recreation and flood control, and they could not justify the cost-benefit ratio. They went up, they were rejected several times. And so they came to Texas. They actually wrote Tarrant Regional Water District. We had the letters in the court's file. Please come and voice your demands for these reservoirs so that we can justify the building of these reservoirs and provide Tarrant Regional Water District with water. These reservoirs are all located within Oklahoma. These are the last major dam sites. So Texas did that. Both Dallas and Tarrant appeared before hearings, congressional hearings. The state legislators, I don't know if some of you are old enough to remember Carl Albert and Monroney and Robert Kerr, who were fairly influential back then. Basically, on the record said, we need to have these reservoirs built so we can supply the Texas needs. With the population in Texas, the cost-benefit analysis was flipped and was positive cost-benefit analysis because Texas was to be supplied. So in the compact, specific provisions were put in. 2.05C, D, specifically say the right to construct reservoir storage of water which is either imported or to be exported. The right to use the bed and banks to convey water for export. Now, these provisions aren't necessary if you're not going to allow a state to go into another state at all. Why do you need this in the compact? So while the court did focus on 2.01 and 2.10 states' rights, they didn't focus on the legislative history after finding that the compact itself and this section of the compact was ambiguous. And the Supreme Court found the definition of 5.05B1 to be ambiguous.
You know, I think you could, on the flip side, make the argument that the water could be exported, but it would be under Oklahoma's authorization. So for the same reason that you could have purchased water rights from the tribes, if a state entity is willing to sell water across state lines, I don't think there's anything that would necessarily forbid that. So I don't know that those particular provisions are definitive as far as using the word exportation.
So Tarrant's key arguments on the preemption side was that the plain language of the compact created a sub-basin that was defined by geographic boundaries, not state lines. And that the compact, where it did intend state lines to matter, specifically said so. And of course, normative rules of compact construction. And first of all, back up. Compact is both a federal law and a contract. So with that in mind, normative rules of compact construction or contract construction say that you shouldn't be interpreting a provision to give no effect to it. You shouldn't be interpreting a provision you shouldn't add words to a compact. You shouldn't rewrite a compact. So that's why the United States said that the plain language supported Tarrant's side, because only by inserting the state line limitation is Tarrant prohibited from going into Subbasin 5 in Oklahoma. Only by deleting other provisions where state line limitations did provide, and these import-export provisions, was Tarrant prohibited from going into Oklahoma. So that kind of sets up the question of how the court ruled. Well, let me jump over real quick to the Dormant Commerce Clause, which wasn't really dealt with in the case, except for it did relax the clear statement rule. Tarrant's key argument in the Dormant Commerce Clause argument was that the language of the statute was admittedly and had been found to be discriminatory. So by the lower court and by the 10th Circuit, they both found the language of the statutes were discriminatory. There was an absolute prohibition against transfer of water, which was then changed to making it incredibly difficult for out-of-state export. So the question is, was there a clear statement rule within the four corners of the compact? Had it been satisfied? And in prior cases, the court had said, you can't look at legislative history. 10th Circuit, the Supreme Court did look at legislative history. So one has to think that the clear statement rule has been modified by the Tarrant case.
So jumping ahead to Oklahoma's arguments, the bottom line is Oklahoma and the amicus parties who favored Oklahoma's position argued that nothing in the compact gives Tarrant the authority to go into Oklahoma physically to divert water for use in Texas. That there would have to be a clear statement of that authority in order for that to be the case. The compact provision for Reach 2 Subbasin 5 created a 25% cap for each state within its own boundaries. But it didn't create a corresponding entitlement to take 25% of the water anywhere that a state chose to do that, anywhere within the subdivision. Oklahoma also argued that the Dormant Commerce Clause doesn't apply to allocated water, and that all of the water under the provisions of Section 5.05B1, that water was all allocated. So Oklahoma statutes didn't violate the Dormant Commerce Clause. And then, so historically states don't relinquish sovereignty lightly, and that was something that the court really took to heart in this case, that looking at other commerce compacts, whenever there were provisions for cross-border rights, they usually included very clear and express language and described the procedures by which that would occur. And provided for accounting and that sort of thing. And there weren't any such provisions here, and so the court interpreted that to mean that, or anyway, that was the argument that Oklahoma made. Also that Texas's past conduct in negotiating to purchase water rights on the same tributary, which it later came in and wanted to divert water from, showed that, there was never this intent when the compact was signed by all of the parties. It was never understood that they would have the right to do that. Otherwise, why buy the water if you could have it for free? And then Oklahoma also argued that if Texas were allowed to divert water in Oklahoma, it would require accounting that was authorized in the compact itself, but had never yet been performed, and that would be a major hardship. So those were the arguments. How did the court rule? Well, it was a unanimous decision by Justice Sonia Sotomayor. The Supreme Court affirmed the 10th Circuit, but on different grounds. And the key rulings were that the court reiterated the rule that compacts are to be interpreted in accordance with general contract principles. So the court looked very carefully at the language used in the compact. And here they found that the court found that the language of this compact was silent on the question of border crossings and whether there were rights to do that. So this silence was interpreted to be an ambiguity. Therefore, the court said that we need to look at extrinsic evidence and in order to determine what the intent of the drafters was. So there were three key points that convinced the court that cross-border rights were not intended to be granted by the compact. The first being the argument that Oklahoma had raised that states do not lightly give up their sovereign powers, including their control over water resources within state boundaries. A state retains sovereignty over water resources within its boundaries. And of course, that's a good result for states in general, though not necessarily for Texas. As I mentioned, the court looked at other interstate compacts, water compacts, and there were a few, very few, and I think Tarrant introduced evidence of those at the Supreme Court level, but there were a few that did deal explicitly and authorized these cross-border rights. But they did so very explicitly, and they had many provisions that set out the mechanics for how this would be done. And, here we have this provision that didn't have any of those types of provisions, and the court thought if that was what was intended, we would have seen that in the compact language. And then the other factor, which we've already talked about, is the fact that Tarrant had been attempting to purchase water from entities in Oklahoma, from the tribes specifically, and that those negotiations fell through. And it's my understanding the water would have been valued at billions of dollars. You probably know that better than I do.
We originally went to Oklahoma, and I want to get into this a little bit later because it's kind of fascinating. We originally offered what amounted to $1 billion. And there was a time when Oklahoma was in a negative deficit, 34 million acre feet flowing out of their state every year. And I guess I have to make the disclosure, these opinions are not my client's opinions, but these are my observations. We had the support of nearly all of the legislative committees in the Oklahoma legislature. Tarrant did. They wanted to see Tarrant win. They did not want to see Oklahoma win. Because to a T, the legislators understood one thing that all legislators understand. They're in there to get reelected. They could not get reelected if they sold water to Oklahoma, or if they gave water to Oklahoma, or if they didn't fight this tooth and nail. And so consequently, they wanted, quote, the cover of a court opinion to allow them to negotiate the deal that they needed to get $1 billion. So that's kind of the nuance behind it. Everybody recognized that by winning the case, Oklahoma got nothing. Texas got nothing. By losing the case, Oklahoma would get $1 billion. Texas would get water. Right now, the water is going to the Gulf. A little sidebar.
I wasn't involved at that point, so I can't speak to that, but that's an interesting backstory.
I want to talk about one thing, and that is, we talked about, the court felt that the prior course of conduct, and they actually pointed out two things. One was that Tarrant had sought this water under an RFP. But again, different water, different location on the Kaimichi, different reach. And it was a turnkey operation, so it was a business decision. But second of all, the court was fixated on two things. They were fixated on the fact that, why now? It's been 25 years since the compact's been negotiated. Why all of a sudden does Tarrant come in and want a cross-border transaction? They should have done it immediately. Everybody in the water industry knows that that's not reality, that you always seek water at your closest, least cost alternative first. And as you grow, you can afford to reach out and get more water at more expensive water. And so from a utility standpoint, that argument doesn't make sense, but it's how the Supreme Court attached a lot of significance to that. The second thing was this thought of accounting, and the court in the oral argument spent probably 70% of their time on this. They couldn't see how a water right could be turned off. They couldn't see what a Herculean task, that was the word used, it would be to figure out how much water is in a river and how much water people are taking from a river. Of course, everybody in this room is a water student or a water lawyer. And in Colorado, we do this every day. That's what gives state engineers their jobs. We know what's in a river and we know how much people are taking out of a river. But that was something that, it was like deer in a headlight. It was one of those things where, and I'll go a sidebar off again, when my friends say we need a Republican selected justice, or we need a Democrat selected justice. No, we need a Western justice in the Supreme Court, because we've lost that ability to understand water after Sandra Day O'Connor and Byron White and Rehnquist have left the court. It was pretty apparent that what was troubling them the most, and most of their questions were related about administration, that you or I would find, why are we talking about this? We should be talking about something else.
Well, that makes me think that Tarrant might have done better ultimately if the case had actually gone to trial and you had been able to develop those kinds of facts and, sidebars and backstories that the court really didn't have the benefit of. And, I know it's through no fault of your own that Oklahoma filed motions for summary judgment, but it would have been an interesting case. Let's say it might have turned out differently, but there you have it.
Yeah. Okay.
This is the one on the meaning of silence, the sounds of silence, which was a big factor here in this case, that Section 5.05B1 did not expressly authorize or forbid a crossing of state borders, so that meant the court had to interpret the silence and what the silence means with regard to that issue. So Oklahoma argued that the silence reflected the drafter's fundamental understanding that state borders must be respected. Ambiguities will be interpreted through the presumption that state sovereignty is never waived without a clear intent to do that, and as reflected by express language in the document itself. But Tarrant's position on that was slightly different.
Well, we felt, and as did the Solicitor General, that the plain language of the compact was important. That where the drafters included state line limitations, they intended to do so. And when they didn't, they intended to do so for a reason. And we provided legislative history to show that there had been state line limitation in Subbasin 5 that had been intentionally removed. And there is, of course, normative rules of contract construction and legislative construction is that when you take a provision out, you assume you did that for a reason that was intentional. And that you should never infer words into a contract or render contracts words useless. So we had a different feeling. We didn't feel as if it was silence. We felt as if it was the plain language. And there have been, a lot of people have written on this case, and I don't know who it was that said, but they had a very good analysis of the case. They said that we've substituted a presumption, the 10th Circuit's presumption against preemption, for a lens of federalism when you interpret a compact. You all of a sudden now have a presumption of sovereignty, state sovereignty, whenever you interpret an ambiguity within a compact. So we've inserted one presumption for another. I thought that was a pretty observant article. So the practical interpretation of the compact. Oklahoma has about 60% of the yield of the Red River in their boundaries. Supreme Court said if you don't like them taking more than 25%, you can always call for an accounting. Useless. Red River doesn't flow into Texas. So what good would an accounting do? This is a unique compact. It's the only compact I know of where the river doesn't flow into another state, flow out of or flow into another state. Very little watershed is in Texas. So in essence, Texas had since 1980 included this water within Oklahoma, within their state water plan. And Texas has some of the most comprehensive water planning of any state in the nation. And they update it every 5 years. And every iteration of that plan has included water in Oklahoma in Subbasin 5 as their entitlement. They thought that was their water. They're not entitled to it now, and there's no way they can get it. So they will end up with much smaller than 25%. Oklahoma can take essentially 60%. If someone wants to complain, they're cut back to 25%. But that just means that a vast quantity of water goes downstream. And when you get downstream, you've got Arkansas and Louisiana, and they have significant uses for their water, mostly navigation and agriculture, because when you get down there, the dilution factor takes the chlorides to a point to where you can beneficially use it at least for irrigation and livestock. But the impact of this decision is that the beneficial use of the water of the Red River will not be used, a significant portion of it. And I guess I would just ask whether or not that was what the drafters intended.
I think that issue is inherent in most interstate compacts, that not every state is able to take its full share. And, Colorado being an example in certain instances. And so we end up without adequate storage, losing quite a bit of water that we would otherwise be entitled to take. So, which also brings up the question, should these compacts be revisited? And that's a whole other can of worms. And I don't know the answer to that, because I think it would be incredibly difficult and something that we'll talk about in a moment later. So we should look at the key takeaways, which are, I guess the most important ramification of this decision is that a state can have an anti-export law if there's no conflict directly with an interstate compact. And the question is whether somehow or other the court's ruling on the Dormant Commerce Clause has somehow weakened the Sporhays case, Sporhays versus Nebraska, which involved a very direct Nebraska statute that forbade any kind of export of water, and factually involved a much smaller amount of water than was at stake here, but the court found that there was a violation of the Dormant Commerce Clause in that case. So unfortunately, the court in this case didn't really delve into that issue very much, but I think it's one that will be coming up in future cases, no doubt. And this relaxation of the unmistakably clear rule, the unmistakably clear statement, by allowing use of extrinsic evidence, which very much was involved in this case. So, and then finally, that states have a sovereign prerogative to control water within their borders, and that if they're going to relinquish that sovereign power, then they need to do so in an express way, and if they don't, then it won't be interpreted to allow that, or to assume that that's the case.
Maybe we only have about 2 minutes here, 3 minutes here, and I think we went too far here, but we should probably open it up to questions or discussions.
We have time for 2 questions.
Geography question.
Yeah.
How come you didn't put your points of diversion in Texas?
No water, no tributaries.
What about Lake Texoma?
Like Texoma is in Oklahoma, and it's not in Subbasin 5.
It's not in the subbasin.
Yeah, and there are intakes. North Texas does take water out of Lake Texoma, but now it's prohibited from doing so because of the mussels in the intake, the endangered species, or not endangered species. What do you call it? Invasive species.
Yeah. Nuisances.
Yeah, I'm wondering, was there any ever discussion or developing of facts about water needed for quality purposes, salinity control, moving the water in the river?
Indirectly, the compact itself says that the compact shall not govern water quality issues. That said, there is a bypass below Hugo Reservoir, a federal bypass in that authorizing legislation for salinity control. There are also, that was argued by Louisiana and Arkansas, that taking freshwater flows, somehow Texas taking freshwater flows would increase salinity. Oklahoma taking freshwater flows wouldn't. Never quite understood that. But yes, and I guess the last point of reference is that at the time this was going on, Louisiana and Arkansas were both trying to sell water to Texas. So it was one of those things to where they didn't want Texas to get water for free.
I think we're out of time. Let's give Kevin and Star a big... So the next panel starts right away, but I'm going to give 5 minutes for transition. So if you need to go get your drink, go to the restroom, we will start at 4:20.